The Pyrrho case, as it's become known to be called, is a case brought by two claimants, Pyrrho Investments and MWB Business Exchange, against 5 defendants. And it's a claim in relation to breach of fiduciary duties by various directors and shareholders in the company. So I'm Ed Spencer, an associate in the Disputes and Investigations team at Taylor Wessing in London.
My name's Stephen England. I'm a senior e-discovery advisor with Milner. Pyrrho was the first decision under the English jurisdiction which allowed the parties, through an order of the court, to use predictive coding.
The reason Pyrrho has come into the spotlight is because of the judgment of Master Matthews earlier this year in relation to use of let's say technology-assisted review or predictive coding, as it is in the judgment, in relation to the disclosure exercise which is currently ongoing in relation to that case.
There have been other cases in the UK where predictive coding technology has been used to expedite review, but by and large that has been by mutual consent of the parties rather than being backed up with an order from the court. So Pyrrho was the first in UK law. When we first got involved, the other side were quite wedded to the idea that there was no proportionate way of undertaking their document review. They believed, and I completely understand why, that they had 20 million documents to review and that there was no way that they would have done that before they retired.
There was a common interest in making sure that disclosure was done properly, but in a proportionate way, with defendants wanting broad date range, lots of custodians, and probably erring on the side of more documents than fewer documents.
The initial proposal, using effectively categorisation, was to review the content of around about 1,000 mailboxes. We suggested that actually, rather than reviewing every mailbox, that actually mailboxes at strategic date points could be taken for each of the custodians. And in doing so, we immediately removed a significant percentage of the sort of pot to go in.
When it was proposed to the claimants, they saw it as an opportunity to fulfil their disclosure obligations, but also keep their costs, which were going to be many millions of pounds, to a much more reasonable level, whilst fulfilling their obligations to make sure that disclosure was done in the proper way, especially across what was a very broad date range and a large number of custodians which had to be searched, really.
What we then did was we put together some detailed information about how predictive coding works and where it's appropriate, where it's not. We ran some simulations using assumptions that the other side produced for us and that they were basing their figures on to ensure that our figures were completely consistent with theirs. And on those simulations, we achieved a 90% saving in the overall document review cost, including the cost of the legal review. And it was a fairly conservative set of assumptions that we used as well. Some of the important lessons that can be learnt from this is that it's okay not to review every document. And I think that's, in terms of the way that people think and the way that lawyers approach their document review, that's probably the most important thing.
So I hope the Pyrrho decision will sort of drive the use of technology-assisted review in disclosure, but also wider than disclosure. It should, and has to some extent already, raised awareness of the power of technology.
Analytics is just another step along the road. I'm sure it will continue to evolve, but it is just another tool that we have that we can deploy for our lawyers to help them do their jobs better.
It's groundbreaking because it will push law firms, clients. It's raised the awareness of the ability of technology to reduce costs.
I think it helps people work smarter. And I think in a world where data volumes are relentlessly going up and exponentially as well, budgets are not following them for what analytics costs. Not using email threading now just makes no logical sense.
Now I think it's going to be much more, well, let's start from the use of we can use technology, we should use technology.
Both in terms of their human review and in predictive coding, there is a margin for error. The difference is that with predictive coding, you get to choose what the margin for error is.
It has such dramatic cost-saving abilities. It is as accurate, if not more accurate, than manual review. It's quicker, cheaper. Why aren't you using it?